Good afternoon and welcome to our third crash course. Today we're going to be talking about the modification request process and how it relates to the new record types that were recently pushed to the DCR licensing portal. My name is Jason Colleen and I'm an Assistant Executive Director with the Department of Cannabis Regulation. So we'll go ahead and get started. So the modification process is basically a mechanism where applicants and licensees can submit information to the department and seek to modify their record. Any modification does require prior written consent by DCR. All modification requests have to be submitted through the licensing portal and associated with the record that is sought to be modified. All of the required documents and information to complete the modification request do have to be submitted before we can process it. And a lot of the modification requests do have corresponding fees that would be due within 30 days of the date on the invoice. And we don't start processing the modification request until the fees are paid. Again, once payment is made, we'll either approve or deny the request, and DCR's determination of whether or not the modification can be processed is final and is not appealable. Right now, we've taken down the modification request function within the DCR licensing portal. We hope to bring it back up sometime on Friday or over the weekend. This is giving us the ability to establish legal business entity records for entities that don't have it, as well as transition folks into the new annual license application process. Since the modification request functions are tied to the different record types, it's important that folks actually have those record types within the system, or they won't have the ability to access those different modification requests. So I'm going to briefly just run through what types of changes get made against different records. On the legal business entity record, this is a new record type that we established last year. And the intent of the record is to have a one-stop shop for that legal entity where all of the owners, whether they're owners, indirect owners, or financial interest holders, that information is housed on that record. The primary personnel for the legal business entity and the authorized agent is also housed on the record. The legal entity's name, any fictitious business names or their DBAs are housed on the record. And then any unique identifiers to the business, whether it's their BTRC number, Secretary of State number, FEIN, that all lives on the legal business entity record. So when somebody seeks to modify any of this information, the modification request would be submitted against the LBIR. And once we've completed processing that request, we can push the updated information down to all of the application and license records below that legal business entity. So from a system standpoint, we refer to the legal business entity record as a parent record. And any application and licensing records are children of that parent record. So once the changes have been done on the parent record, we have the ability to push that information down to all of the child records. This new record was intended to, one, make the application process simpler so that we wouldn't have to re-review legal entity related stuff for businesses that have already been vetted by the department. It was also intended to simplify the modification process. So instead of a business having to submit modifications against all of their different application and licensing records and pay applicable fees on each of those records and have their assigned analyst process each of those individually, we now have one standalone record that houses that information. So the request can be submitted once, the fees can be paid once, and then once it's been processed, it can get pushed to all of the other records. So one, it makes the department more efficient. Two, it makes the process less expensive for the applicant or licensee. And then three, it ensures that changes made against one record get applied to all of the records, so there's consistency there. Next is the type of modifications that would get applied to application or licensing records. That would include updates to the business premises diagram, updates to the attestation. We may need additional attestation documents based on ownership changes or primary personnel changes. Those attestations all live on that specific application record, the indemnification agreement, and then environmental review documents. Those also live on the application records. So these are different modification types that can be submitted while an application is being processed, whether it's during the application phase or after a license is issued, just to make sure that the information is always up to date. Hopping into relocations, there's 3 different ways a relocation may be facilitated. The first way is when an application is deemed abandoned. So the location, the review for distancing and sensitive use and zoning all happens at the pre-application record stage. So once the pre-application record has been deemed eligible for processing, the activities listed on the record and that location are really locked in. So when an application has been submitted, the only way to restart the process and allow for you to reapply at a different location would be to abandon the application record so you can restart the process. Under the updated code, businesses may relocate within the same community plan area and under certain circumstances to another community plan area. For activity types that are subject to a finding of undue concentration, they can only be relocated to a community plan area that has not reached undue concentration. The other way a license can be relocated is once it's been issued. So we've allowed for folks to relocate temporary approval. In order to relocate temporary approval moving forward, you're going to have a new state provisional or annual license. We will be sunsetting the temporary approval application process for social equity applicants on July 31st, 2023, and it's already sunset for general applicants. So at this point, if folks are looking to relocate a temporary approval license, most likely you're going to have to obtain an annual license first so that we can complete the environmental review for the location, adopt a CEQA report, which will help facilitate you being allowed to update your state application records so that then you could relocate your corresponding state license. Given the fact that the state has adopted a dual licensing requirement, having a license either from the city or from the state without the corresponding license doesn't allow you to operate. So because temporary approval is a form of temporary licensure that is intended to correspond with the state provisional process, if you can't get the state provisional license or another form of license from the state to operate, there's no value in giving you temporary approval at a new location until you've met that requirement. The same holds true for the annual licenses, but for the annual license, you get the benefit of having an adopted environmental report. So the state should have a streamlined process for businesses that have adopted environmental reports that will help facilitate either entity substitutions, changes to the legal entity that the license has been assigned to, and then of course the relocation. So we will be pushing folks to get through the annual licensure process to give you the additional benefit of being able to relocate those licenses either to within the same community plan area or to another community plan area. And then of course, once we review the request, we'll determine whether or not the environmental document that was adopted for your annual license is transferable to the new location. For the annual licenses, because the annual license does not require a final inspection until after you've received your state license and met all of the permitting requirements, a license can be transferred to a different location. However, you will have to get the corresponding state license and meet the permitting requirements for the new location to obtain your operating permit to use the annual license at that new location. The next thing we'll be talking about are the modifications that require one or more new record types. We created a process for entity substitutions that is primarily facilitated through the application abandonment process. There's certain social equity individual applicants and entities that have been given the opportunity to apply for a license. And sometimes they need to make amendments to their application record. And both at the local and the state level, we've always required people to submit a new application record. So what the entity substitution process did was if a application record was deemed abandoned, there is provisions within the code that allow for it to be refiled. And depending on the type of record it is, sometimes you can actually change the legal entity that is then applying for the commercial cannabis activity. Separately, with the creation of this annual licensing process, we're going to have a license transfer process, which would allow for the annual license to be transferred to a new entity. The new entity must have an active legal business entity record and demonstrate that it meets the license transfer requirements. So for instance, a social equity annual license cannot be transferred to a general applicant. The entity that it's being transferred to has to meet the requirements under 10420 in order for us to transfer the license. By making sure that one, the entity seeking to get the license has a legal business entity record and it's already been verified by the department, that facilitates a smoother transition if the entity is eligible to receive that license. So making sure that whatever entity is looking to obtain the opportunity to get the license has the legal business entity record, they've gone through the review process, will facilitate a quicker turnaround on determining whether or not we can transfer the license. If we do determine that we can transfer the license, then of course the new entity will have to get their state license as well as obtain an operating permit before being able to utilize that annual license. Assuming that, the fire permit requirements, the building and safety requirements are already met, the entity may just have to pursue a health permit with LA County Public Health as well as their state license in order to request a final inspection and get the operating permit under the new legal entity. So those are some of the changes. And then of course, if we do allow for the license to get transferred, as I mentioned, the legal business entity is a parent record. So what would happen is the child would get adopted by the new legal business entity, and then that license record would be housed under that legal entity on a go-forward basis. So any of the work and the analysis that went into issuing that license would follow that license to the new entity. As I mentioned, we are in the process of updating the system and transitioning the records that we have into the new record types to help facilitate this modification process. So we will be sharing screenshots of the system and the different workflows within the system to facilitate these modification requests at a future date. And hopefully that will be either sometime later this month or early in July. We're going to go ahead and take a brief 5-minute break. Welcome back. We're ready to get started with the question and answer session. Gidget, I'll turn it over to you.
Good afternoon, Jason. Our first question comes from Kimber. After annual licensure is finalized, can you confirm if LA annual licenses can be transferred to a new location, and if CEQA analysis will need to be completed again for following a relocation to the new premises?
Great question. So once an annual license is issued, when a relocation modification is submitted, we'll review the request to determine whether or not the original CEQA analysis is still valid, and if it can follow the license to the new location. There's going to be some site-specific review that we have to do, but if it's like to like, there's a good chance that the original SQL analysis will be sufficient and can just follow the license to the new location.
Okay, moving on. The second question also comes from Kimber. What are the circumstances that a project can be moved to another CPA?
So the municipal code allows for, so a license that is not subject to a finding of undue concentration, non-storefront delivery, non-volatile manufacturing, distribution transport only, testing labs. Those licenses may be relocated to any CPA within the city, either through the refiling process or through the relocation modification process. Activities that are subject to a finding of undue concentration, retail with on-site sales, volatile manufacturing, which we haven't begun accepting yet, and cultivation, those can be relocated within the same community plan area, or under the new code can be relocated to a new community plan area, provided that community plan area has not reached undue concentration. And then, of course, for community plan areas that have reached undue concentration, the only way DCR can move a license or an application to that community plan is if the applicant received a public convenience or necessity finding from the Los Angeles City Council.
Okay, thank you, Jason. The next question comes from MS. What is the status of an online payment mechanism for modifications, and when will the online payment system be available?
So we're working with Excella and the Office of Finance to establish the interfaces between our systems to implement this online payment solution. And we're hopeful that the solution will be in place by September 1st in time for the renewal process.
Another question from MS. If an existing medical marijuana dispensary is trying to relocate, should they submit a 4013 form for their current location or their future location, or both? What is the best method for receiving an annual license at their new location?
If a request has not already been submitted, the business would most likely want to go through the annual licensure process at the existing location if they have the ability to do that, because an EMMD is not a local equity applicant, so they aren't in a position to get a state provisional license at this time. So in order to operate at the new location, they of course would have to go through the local annual licensure program into the state annual licensure program. Because annual licenses are going to be transferable, it may be easier for them to get the annual license at the current location, and then once they have that, transfer the annual license to the new location to facilitate getting their annual state license at that location more quickly. For the non-retail activities, if the EMMD is vertically integrated, we anticipate that recommendations to issue annual licenses will go to the director sometime late summer. And then for the retail storefront component, DCR staff will start to transmit recommendations to issue annual licenses to the Cannabis Regulation Commission sometime this fall. The retail with on-site sales does require community meetings as well as public hearings. So that process to issue the annual license will take longer than it will for the non-retail. So if you try to relocate before then, you'll most likely lose the ability to operate at your existing location because of the 180-day requirement for the license to be active before transitioning to the new location. So it's something you'll probably want, the business will want to think about how quickly they can move through the process at the existing location. Do they still have site control to move forward at the existing location? Or whether or not it would make more sense to abandon the existing record because they lost site control so that they can start their annual license application at their new preferred location.
Great. Our next question from Tiffany W. What is the difference between a modification to substitute an entity rather than transferring the license? LBERs have been completed for both the old and new entities.
So an entity substitution is effectively the applicant choosing to pursue a commercial cannabis license as a different legal business entity. The entity substitution requires a brand new application, and that applicant has to go through the entire application process, versus for a license transfer, the city has already made a decision to issue an annual license and done whatever hearing processes and adoption of environmental reports necessary to issue that license. And basically that license is now being treated like an asset that could be bought and sold independent of the entity that it was issued to. So under either circumstance, a legal business entity record will have to be completed for the new entity. Under the entity substitution process, the new entity would become the applicant on a new application, versus on a license transfer, the new entity would be the beneficiary of receiving that annual license, provided they meet whatever the licensing requirements are for that license type.
We have a follow-up question from Tiffany. What is the fee for a modification request to transfer the license? Is it the same as the $6,000 invoice for entity substitution?
It's not the same. The fee is less than the entity substitution, because for the entity substitution, the new entity has to submit a new application, and that new application has to be processed. Versus for the license transference, we're looking to verify whether or not the new entity is eligible for that licensure type, and do they meet the requirements for how that license was issued. You know, was it a general license? Is it a social equity license? Does the entity meet the requirements to either possess that general license or that social equity license? So because we're not processing a new application, the fee is lower. And then of course the new entity would be subject to, you know, meeting the permitting requirements, paying for the final inspection, and then pursuing the operating permit as the new legal entity.
Thanks, Jason. We have a similar question from three individuals who are Anahi, Ariel, and Rafi. And they ask, how can we get numbers on undue concentration for cultivation? Are there any community plans that are maxed out on cultivation?
This is an interesting question. So the first thing is folks can submit a California Public Records Act request to DCR CPRA request@lecity.org. And if somebody on the team could just drop the email into the chat, that would be helpful. But we've received a number of requests for this information. So if you send us an email, we can drop you into the queue to receive this information once we've pulled it. We are in the process of compiling this information. We do have to make sure that we transition the existing pipeline into the new annual record to make sure that we're not double counting or missing any of these records, and then we'll produce the information and make it available on the website. But if you do send us the email, you'll be one of the first people to get it once the record's been created. The last time I checked, there were a few community plan areas that had reached undue concentration. Specifically for the cultivation activity type, the code limits DCR to 15 cultivation licenses per community plan area. As folks know, it only counts towards undue concentration once a license has been issued. So of course, temporary approval is the form of licensure, so temporary approvals count. But a lot of those phase 2 applications that are still pending that have never resulted in a license, they have an opportunity to get a license. But if they don't have a license yet, it's not counting towards the 15 limit, which means that that community plan area would not be subject to a finding of undue concentration. So as I mentioned, we're compiling the data. Once we finish the record migration, we'll be able to make sure that the numbers are correct, and then we'll provide responses to folks that have already submitted the request for this information. New folks that come in will be able to provide the record, and then this is something that we're going to make available on DCR's website as soon as it's available.
Perfect, thank you. Jesse F. asks, is DCR still planning to reopen the PCN application process in or around August 2023?
That's still the working plan, unless we're given direction otherwise.
Okay, moving on from Rafi S. If we need a provisional or annual state license to process a relocation, how can we obtain that without a submitted application with a CEQA exemption from DCR?
That's kind of the key there, is all roads moving forward lead to obtaining an annual license at the local level so that you have the necessary document to get the corresponding state license. So if folks are constantly restarting the application process at new locations and they're never getting an annual license, they're never going to be able to operate, and they're never going to be able to meet the requirements. So the goal is to get people into the annual application process, let folks obtain their annual licenses, and then that will help facilitate being able to move that license to a new compliant location, because we will have done the environmental analysis, and that analysis may be applicable to the new location that they're seeking to relocate to. The state has also kind of created a streamlined process for moving a license, provided the environmental documentation has been adopted at the local level.
Our next question comes from Tiffany W. Why are public hearings required for issuance of an annual retail license?
The Los Angeles Municipal Code has always required that recommendations to issue the retail storefront with on-site sales license type go through a community meeting as well as public hearing process facilitated through DCR for the community meetings, and then the Cannabis Regulation Commission for the public hearing process. So it's a requirement in the code for DCR to issue the annual license, or to make a recommendation for the commission to issue an annual license.
Tiffany has another question. Why is an inspection required for a license transfer?
So an inspection isn't required for a license transfer. But when a license is transferred from entity A to entity B is going to have to get their own health permit, because the health permits are entity specific. They'll have to pursue their own state license because it's entity specific. And then once entity B has a state license and the health permit and any other permits they may need, then they can request a final inspection. And passage of a final inspection is required to get an operating permit. And the operating permit is what would allow entity B to utilize and operate under that annual license. again, because of the dual licensing requirement, just getting a license from the city or the state isn't sufficient. So the final inspection is the local protocol to verify that the licensee has met the local licensing requirement, the local permitting requirements. They meet the state licensing requirement. We do the inspection, and then we allow them to operate using those licenses.
Our next question from Paula B. If a CEQA determination is explicitly tied to the land, wouldn't a new CEQA determination and a new state license still be required to move a DCR city license?
It depends. So you can look at the 450 plus square miles of city and say that the city has analyzed the zoning and the distancing requirements, and DCR has validated that the project has met those requirements, and issuance of the license doesn't trigger an environmental impact, and that license has been issued within the city, and moving that license from point A to point B, provided it still continues to comply with the zoning, distancing requirements, et cetera, wouldn't have an additional impact on the city because we've already issued the license. And to the extent that they're moving the license for permitting purposes, health permit, fire permit, building and safety permits, et cetera, or ministerial actions, what is the impact of that license moving from point A to point B? It's something we'll have to look at as part of the license transfer process, but it may not require us to do another environmental review because, again, it's a license issued within the city of Los Angeles that has met our local requirements, and it would be relocating to another compliant location within the city, and we're not creating a new license or a new impact potentially.
Our next question comes from Rachel W. What is the time frame or process for modification request for transfer of a social equity applicant to a new social equity applicant of a business entity once the fee has been paid? Jason, did you hear my question?
I did.
Okay.
I'm trying to think of a concise way to answer the question.
Okay, just wanted to make sure I wasn't on mute accidentally.
No, I heard you loud and clear. If the original application was deemed abandoned, then it may be eligible to be refiled as a different entity. And then, of course, payment of the application fees would facilitate DCR starting to process the application. If a license has been issued and we're looking at transferring the license to a different entity, the entity that would be pursuing the license would have to have an active legal business entity record. That means that the legal business entity B in this case, has already established their business tax registration account. They have a legal business entity record. The owners, indirect owners, financial interest holders, primary personnel have already been vetted. If applicable, DCR has done the equity share review for that legal business entity and deemed that based on the information submitted, it appears that they comply with 10420. That would all have to be done before DCR would be able to consider transferring a license from social equity applicant A to social equity applicant B. And under this new modification process, if social equity applicant B hasn't gone through the equity share review and it's a social equity license, we would reject that modification until such time social equity applicant B has gone through the equity share review.
Okay, our next question from Rafi S is looking for some clarification. Will we have to get an annual license before we can apply for a state license?
Yes and no. You can apply for a state license at any time. But for the state annual licensing process, they require an adopted environmental report. And the only way you can get that local adopted environmental report is to have gone through the local annual licensing process and then had either the director or the Cannabis Regulation Commission adopt the findings to issue an annual license, which would include that environmental review. So you can apply at any time with the state, but you won't be able to meet the state's annual application requirements without having been granted a local annual license. So hopefully that helps.
Thank you, Jason. Michael is asking, I was selected in the lottery. How can I add retail to my location where I currently have 5 licenses?
So if you were selected through the phase 3 retail round 2 lottery, that gives you the opportunity to submit an application for the retail storefront activity. At this point, it would be a standalone record. So your lottery selection record, if you were selected, would have an action required button next to it, which would give you the opportunity to submit a pre-application record for your preferred business premises. And then that record will go through the land use review to determine if it's eligible for further processing for that activity type. And then ultimately, if it is, you would have the ability to submit an application. At this time, you're not going to be able to commingle records that have active licenses with pending applications. But at some point in the future, if you do get licensed for that activity, there may be a way to consolidate your licenses into one record. But it's really 6 of one, half a dozen of the other for us, because the renewal fees and everything else are really tied to the activities, and you don't get a discount if you have more licenses at one location than just having, the same number of licenses spread across 2 or 3 records.
JJ asks, will there be additional extensions for applications deemed abandoned after their year is up? If so, what is the process?
So this ties into recommendations DCR had made earlier to the city council. Under the new law, the records that were deemed abandoned may be refiled within 3 years of the date of abandonment. So the 1 year has changed to 3 years, and that is now law. So any of the records that were abandoned, sometime in early to mid 2022 are going to benefit from, the additional 2 years, and, your record would still be eligible for refiling.
Okay, our next question from MS. What happens if a lottery recipient does not make any progress with licensure in 1 to 4 years?
Then the application opportunity could be granted to another applicant as part of a future lottery process.
Okay, moving on from Brandy B. What is the status of fee waivers for newly issued licenses?
So if it's a newly issued license, the local jurisdiction assistance grant monies may be eligible to provide fee waivers for the annual license application process and community meetings and other things that are necessary for whatever the commercial cannabis activity type is to get to annual licensure. If it's, a newly submitted application, we may or may not have grant fundings that would allow for DCR to provide fee waivers based on the activities and kind of what the circumstances of that particular record is. The best course of action is generally to reach out to the social equity team and just inquire what different types of programming and fee waivers may be available through the various social equity programs they're administering.
Right. Anahi is asking, please clarify, does an applicant who plans to move need to conduct an environmental review at the existing location? However, the paperwork and all other permits would be for the new location.
So it depends. If an applicant, so there's no license associated with the current property, and you lose site control, that could result in the record being deemed abandoned, and it may be eligible for refiling at a new location. So if you have a pending application that's abandoned and it gets relocated and you file a new application at the new location, then you would submit the documentation associated with the new location, and then the environmental review would be conducted at the new location. Completely new application, completely new application review, completely new environmental review. If you're a licensee and you have temporary approval at an existing location and you're operating and you still have site control, it may be to your benefit to pursue annual licensure at that location so that once the annual license has been issued, you can look to relocate that annual license to another compliant location within the city. That would enable you to continue operating at your existing location, utilizing temporary approval while you pursue annual licensure, and then ultimately pursuing the corresponding state licenses for the new location. If you don't have a corresponding state license and you can't lawfully operate at the new location, it really just becomes a business decision as to whether or not it's beneficial for you to get your local annual license and relocate the local annual license to enable you to then apply for a state annual license at your preferred location.
This next question is long, but bear with me. I'll try to make sense of it. Let's see, from MS. If a social equity applicant who has temporary approval is transferring their ownership for the licensed entity to another social equity individual applicant, does a new equity share review need to take place even if the equity share document, which has already been approved, is the entity's operating agreement and would not be changing? Is there a DCR doc, maybe Form 6001, that would be sufficient to efficiently check off ESR for the new SCIA? Let me know if you need me to repeat any part of that.
I'm going to cop out and just say it depends. So it's really going to depend on the review of the purchase agreement and whether, for instance, if it's a corporation and it's merely a stock transfer from one social equity individual applicant to another, and you attest that all of the corporate bylaws and everything else remain the same. There's no change in the value or the equity of those shares. That may be sufficient. Some folks have different provisions within the operating agreement that may trigger when shares are transferred. And that's something that the team has to kind of be aware of and see whether or not that triggers a potential clause within the operating agreement that could violate 10420. If it does trigger something that could violate 10420, we may require a new equity share review based on what the corporation's going to do with that new information or that new owner.
Thank you, Jason. Our next question comes from Rafi S. Please confirm that when you apply for a state license, they will require CEQA before you can submit an application.
If you're applying for a state annual license, they're going to ask you whether or not you've completed the environmental review at the local level and you have an adopted environmental document. Just like folks do at the local level, sometimes people upload placeholder documents to trick the system into allowing the record to be created. And then when we start to do our review, we find out that it's a placeholder document. At the local level, the application is not deemed filed until we have all of the forms, documents, information, and the fees are paid. And if we do find that there's a placeholder document, we may give you the opportunity to cure that deficiency, depending on whether or not it's one placeholder document or, in the event that they're all placeholder documents, we would just abandon the record and require you to refile it. For the state application, they do have a cure period, and the analyst may give you the opportunity to cure the deficiency. So you could get an application in before you have everything you need to have a complete state application. But again, there's a risk to that because the state may require you to withdraw your state application if you're not in the position to give them the environmental review document that they need for your application to be deemed complete within their processing timeframes. I would recommend that you reach out to the Department of Cannabis Control with any specific questions about when a local business could foreseeably get into the state queue and then provide additional supplemental information to meet the state's requirement without, either having their application denied or withdrawn. Because they do have different analysts, they do have different requirements and expectations when an application gets submitted.
Thanks, Jason. We have a question from Michael F. If I have a retail license just awarded by lottery and I already have property that is an area of undue concentration, however, I have 5 licenses at this location, how can I add a license here?
I think so. For social equity individual applicants selected through the phase 3 retail round 2 lottery, the lottery selection gives them the ability to submit a pre-application record within 1 year. And if that pre-application record's eligible for further processing, then they have the ability to submit an application. So if you were granted the opportunity to submit a pre-application record for the retail storefront activity type, we would only be able to consider that if it was submitted in an area that was not subject to undue concentration. If it's submitted in an area that's subject to undue concentration, DCR does not have the authority to process an application without a public convenience or necessity finding by the city council. And as one of the other folks asked earlier in the Q&A, that process is not currently open, and unless directed otherwise, we plan to open it sometime in August of 2023.
Our next question from Mike B. Is there a deadline to submit modifications, for example, entity substitution for cultivation activity on a license, on a license that is currently inactive but not abandoned?
I mean, fundamentally, the entity substitution at this point is really tied to the abandonment process and the ability to refile. If you have a license and you have site control, and you may be able to pursue an annual license at that location and then seek to do a license transference to move the license to a different entity.
Okay. From Mike B. When moving a cultivation license to a new entity, is there any implications at the state or CDTFA level relative to tax liability that is currently associated with business operations at the associated distribution entity attached to the cultivation license?
The answer is it depends. For tax related questions, whether it's at the state or local level, for the state, you do want to reach out to CDTFA and run them through your scenario. And then at the local level, talk to the Office of Finance. But vertically integrated businesses have different tax liabilities based on their activities. So if you're basically breaking up the vertical integration, it may change where your liability comes in within the taxation process. And then, of course, the end date for the existing entity engaging in that activity and the start date for the new entity engaging in the activity will trigger when business A is done with their liability for the activities and when business B starts to accrue liability for their activities. But it's best to always advise a tax lawyer and reach out to the agencies that administer the tax code for your specific circumstances.
Thank you, Jason. Another question from MS. When DCR updates the sensitive uses on its licensing map, are new storefront retailers included?
My crystal ball says no. The sensitive uses are updated on a quarterly basis, and DCR downloads the sensitive use data and provides it to the Department of City Planning. And then they use the ArcGIS platform to geocode the different layers for the sensitive uses. Our ability to really manually update the system for the different types of retail activities that could create a buffer or may create a buffer in the future, it's been really hard to keep the layers updated as we would like, because of course the Department of City Planning has their own GIS needs. And what we're looking to do is we're going to actually remove the retail elements from the sensitive use map, and we're going to have another map embedded on the DCR website that'll just focus on the records with retail on-site sales, and then be able to adjust that on a more frequent basis. We are working with the Excella team, and there is a solution that will allow us to integrate the licensing portal data with Google Maps so that it gets refreshed on a weekly or a daily basis. So the information is more user-friendly in real time than it is under the current system and methodology. So once we get folks transitioned over to the annual records, we will be able to set up that interface and then start to publish more up-to-date information so that people can take that into consideration as they look for compliant locations.
Our next question from Mike B. I'm currently waiting to get my LBER approved on my distribution and cultivation activity from renewal status to temporary. Can you explain the steps to create a separate or a separation of entity between the two licenses and change owners, address, and community plan?
I mean, based on how I heard the question, the business has been issued a distribution license and a cultivation license. And it sounds like they want to bifurcate at least one of the licenses to a different legal business entity. So, at this point, you would really either be looking to abandon one of the records so that it can be refiled as a different entity if that's an option, or looking to get your annual license or license so that then it could be transferred to the other entity. And that other entity, of course, would have to have an active LBER, which would reflect the owners of that entity. And then separately would be like a relocation if you're looking to relocate one of the licenses to a different address or community plan area. That's going to be very record specific, and it would probably be best to reach out to your assigned analyst for your current record so that you can walk through what you're attempting to do. Because, it sounded to me based on the question that one aspect was moving one or more of the licenses to a different entity. And then the second part was relocating those licenses somewhere, whether it's within the same community plan or a different community plan. But there may be a way to facilitate that, but it may be different. It may be multiple modification records, and you may have to see one modification record through to completion before you can initiate the next modification.
Thanks, Jason. We have a question from MS. Does the new ordinance update specify whether a lottery record, which is eligible to submit a pre-app, would be abandoned if the pre-app is not submitted within a year?
My nomenclature is going to be a little bit different. So folks selected through the phase 3 retail round 2 lottery are granted up to 1 year to submit a pre-application record. So the lottery record will just close after 365 days. So at the 1 year anniversary, the lottery record is just going to close. So if a pre-application record was submitted, that could be in process. If one was never submitted, the lottery record's closed and you don't have the ability to submit the pre-application review. So if you don't do anything, it's not like the lottery record gets abandoned and you possibly have the ability to refile. You lose the opportunity to apply in the first place.
Okay, I'm seeing one other question from Mike B. How can I drop down from a tier one owner so I can sell my cultivation activity without owning the requisite 51% majority stake?
So the only phase one and phase two applicants have been able to apply for the cultivation activities. So assuming that this was a phase two record and it was treated as a tier one social equity record, you would submit an ownership modification, and you may drop down to a tier two owner, which means that you own at least 33 1/3% of the equity, or you and some combination of other social equity individual applicants own the requisite equity for it to still be considered a social equity record. If you don't have an ownership of social equity individual applicants that meet the requisite equity stake for it to be considered either a tier one or a tier two record, then it's considered a tier three record, and the entity will have to enter into a social equity agreement and meet the social equity agreement requirements as part of the annual application process. But again, all ownership changes are done against the legal business entity record. And then when we look at the record and the license types that could be impacted, we would determine whether or not we're in a position to process that modification request.
One additional question coming from JJ. If I paid the relocation invoice on a location property, but haven't completed LBER, I now don't want to complete it since I have extended time on the abandoned application. Will that paid invoice be deemed abandoned to resubmit?
So my understanding of the question is they submitted a relocation request, they got an invoice, they paid the invoice, but they haven't completed the legal business entity record. And now they're wondering whether or not whatever record the modification was submitted against could be deemed abandoned so that they could resubmit the application at a later date. That's going to be something that you'll have to talk with your analyst about so that they can look into your specific records to determine what the appropriate course of action would be and what forms we may need to facilitate the request.
I'm not seeing any more questions in the Q&A function, so I think we are done. Jason?
Thank you so much for your time today, Gidget. And
You're very welcome.
just a reminder for folks, I will be doing a Q&A virtual lunch tomorrow. So if you have any questions or you think of some later, feel free to join us tomorrow. And that will be going on from noon until 1. Sometimes if I don't have another afternoon meeting, I can go for an extra 15 minutes or 30 minutes, depending on the availability of the team to continue to support it. But we are doing a virtual lunch tomorrow. It's open for whatever questions you may have. So if you have any more questions or you have questions that were unrelated to the crash course, please feel free to join us tomorrow at noon. So with that, I want to thank everybody for participating today, and thank you for the DCR team for supporting us. And that concludes today's crash course. Goodbye.